have about an hour and a we are recording it and we'll make a decision about where and when it's posted subsequently. Um, we also, I think, want to make sure everyone's muted. Some folks are not. So, Nick, if you could just help me out when you notice that participants might have inadvertently unmuted themselves, that'd be great. And we are happy to have you put questions in the chat. And Nick, if you see a reason to interrupt me, please feel free. But we're going to be covering a lot of material. Susan, Kim, and I had a conversation about some interest in providing the network with some background, some historical information. So this is a little bit of a different presentation. We're not going to be covering a lot of extensive research or code sections, although there'll be a few references. And it is a very, I should say, what I bring to it in terms of my own work is a perspective that's heavily rooted in policy, also great interest in history. And this area is so rich, so rewarding, so diverse in terms of the history of domestic violence as a movement, as a policy field, and especially in California. So I'm going to leave a lot of things out that some of you with a different set of experiences or perspective might notice or wish I covered more effectively. So apologies in advance for that. But I come to this as an attorney and social worker who began being paid to work on gender-based violence in 1994. So I've been doing this work for a little over 30 years. And I say starting to get paid to do this work because my sense is that there were a variety of ways that I was addressing and being exposed to issues related to gender-based violence long before I got into it professionally, just as a term and condition of being female in this country, in the world, and also working on unlearning bias, unlearning racism work uh, before I got into the field of domestic violence work. Um, so I'm gonna jump into it, and hopefully uh, you'll get a lot out of this. And again, you all have a rich set of stories and experiences as professionals and individuals in this world. I have tremendous respect, of course, for the uh, perspective of survivors, and I've tried to capture some of that over the course of our history here. Uh, and some of what I'll be talking about, because we're talking about intimate partner violence, is, of course, very disturbing, upsetting, and I want folks to know you can make sure you have some water, make sure you take a break as needed, and take care of yourself because this is never an easy topic, even though I find, after 30 plus years of working in this field, incredible inspiration and motivation, and have a lot of optimism about the work we can do collectively to make the world a better place and to heal the world. So I bring that perspective to what I'm going to be talking about. So if you take a look at this statement, if we were in person and had an easier time with folks being able to raise their hands, but you could feel free to put in the chat when you think this statement might be from, this description here, which is probably not unfamiliar to you, all of you who work in this field. A description of a history of domestic violence impacting this individual woman, her children. I'm just gonna move this around a little bit so I can see you all a bit better. And that she's experienced not only physical violence, but damage in her home and uh, fear. So I don't know if anyone wants to drop in there when you think this might be a description that particular point in time, a year, a time frame. Uh, because what I usually get when I do this presentation is it could be anytime, it could be now. It's something that people find familiar from work they've done yesterday. This is actually a piece of writing from Frances Power Cobb, who was a women's rights activist in England. She was writing about this in 1868. This is obviously a long-standing issue, both the experience of domestic violence, intimate partner violence, but also concerns, the particular concerns related to property damage, concerns about harm to the children, and reliance on the legal system, both the criminal legal system and this idea that there would be some kind of remedy that would protect her and her children from the violence that her husband was perpetrating. So this is not new. And England had ways of protecting victims of domestic violence before we did in the United States. Orders of protection, the civil response was not available here in the United States until the mid 1970s. Now, that doesn't mean that England was outlawing and prohibiting domestic violence, but there were limits to the kind of violence that could be perpetrated. Uh, this comes from a concept called coverture. And, there are so many aspects of how we can think about intimate partner violence historically. And I'm going to really take a perspective that emphasizes the significance of the concept of property in the United States. It's a very important legal principle conceptually. Property in terms of what we can think of as land, buildings, dwellings, ownership of physical, non-living aspects of our world, but also in the United States legal system, property, which is a core tenet of how we think about the role of the courts, private property, who should control property, is very much, tragically, in my view, tied to human beings. So if you study early constitutional analysis of the Commerce Clause, which is the basis in our Constitution for congressional power, that Congress shall regulate trade, commerce between and among the states and Indian tribes, which is referred to then as the Indian Commerce Clause. Early development of that constitutional principle that set forth the limitations on congressional power, the expanse of congressional power, many of those cases were around the importation, management, purchasing, owning human beings through the African slave trade. So the notion of property and the ability to own or control human beings is a core part of our legal principles in many respects to this day. So that's a legacy we have to wrestle with. And it also shows up in the context of marital relationships, which is a legal construct. And coverture is a concept that came from British common law, which is what the bulk of our law here in the United States is based on. And it was this notion that a woman who was on her own was initially without a husband called a femme sole in Latin, a single woman, and could engage in certain business practices. But once she married, she was covered by her husband, and they became one legal entity, and he was the legal entity. She became essentially part of his property. And that it's not a particularly political position, it is a legal reality. And we can see that at that time, in the early we're talking about the 1700s through the 1800s, much of the 1800s, coverture, and then beyond that, those coverture laws meant she couldn't own property, sign contracts, start a business, keep any money she earned. She couldn't be sued or sued. Her husband was responsible for any personal injury, which allowed, under our law, a certain level of correction because if she was going to behave in a way that would cost him money, he needed to be able to curtail or limit her freedom to stop her from behaving in certain ways. So there was a certain amount of violence that was allowed to be perpetrated. In exchange for this kind of control, he also had certain obligations to take care of her, although those were also extremely limited. And we have lots of early case law on that as well. Um, she also was not in a position once you married to refuse sex with your husband, and that's where we have a whole legacy of spousal or marital rape laws. It wasn't until the Women's Property Acts, Married Women's Property Acts, that we started to see some removal of these restrictions that existed as a result of coverture. The first one was in 1839 in Mississippi. And, a lot of folks, when I ask them, when I'm teaching this in other contexts, and we ask, when do you think the first Married Women's Property Act, the first set of laws that really removed those restrictions and allowed women to inherit and control property, what part of the country, what state do you imagine that emerged in initially? And very few people think of Mississippi. Now you can imagine, based on what I've shared, why that might be. And the answer is that the restriction on a wife's ability to control property or a widow's ability to control property was limited, which meant that she did not have the ability to control the slaves that her husband owned or to inherit the slaves that were associated with the property. So, in that context, it is unsurprising, really, that you'd have a situation where the first place that you start to see this emergence of some kinds of rights were associated with white women, the slave owning class, so that wives would be in a position to ensure that their husband's property stayed within the family. So you're going to see this tension throughout the policy that I'm going to be talking about. That is, we can't always think about women's rights and liberation as a progressive concept because class and race, gender ideology, the intersection of all of those issues, all of that plays a significant role in thinking about why something becomes part of the liberation of some, often, too often, at the expense of others. But that was the beginning of thinking about women as having certain rights. And again, a certain set of women, a certain subset. Meanwhile, in California, we have our own history, and of course, that's something we can't cover extensively here today. But in terms of the early days of California history, having been Mexico, having been influenced by Spanish law, which included support for what we think of today as community property. So it had a very different set of laws than British common law. California was shaped by that history of Spanish colonial rule as well as French influence. And in 1849, interestingly, there was a constitutional debate. So this is around the same time that these discussions of married women's property rights was being had across the country. And the debate included this conversation. This is one quote from one of the delegates who was helping to set up the California Constitution in 1849. That was our first constitution. Um, and this particular individual is representing the thinking that, this has worked so far, so why should we make any changes? It keeps people happily married to have the husband in control of the property, and to take care of any wealth, any money, gold in particular, because this is all happening in the context of the gold rush, under his control. But there were disagreements. There was a perspective that said, there is a lot of money here, and a lot of people are losing money. They make a lot of money, they lose a lot of money. It's a roller coaster. It's a lot of up and down here in the gold rush period and area. And we want to make sure that the wealth doesn't just disappear. So having women be able to have some influence and control over the wealth within a family would be advantageous because of concerns about speculation and loss of wealth. And another significant reason why California baked women's property rights into the early Constitution was an interest in, as this cartoon depicts, having more women who were available to get married in California. There was a big concern at the time that there weren't enough women in California. And so it would make California more attractive, was one of the arguments, if we afforded women certain rights. And this is a cartoon showing a box of women, and it's in French, uh, being brought to California so that they could be married off, marriageable women. And additionally, that influence of Spanish law supported the notion that women would have similar, almost equal rights to property in California. So we were an early adopter here in the state of that policy. Our first constitution was translated into Spanish, so we had an English version of the Constitution and a Spanish version of the Constitution. We also had written into that first Constitution that all laws had to be published in English and Spanish. It was a requirement that we had a bilingual approach to policy for the first 30 years of rule under the Constitution in California until the next version in 1879 that removed that. We also had in the early days and continue to have this influence on the law that impacts intimate partner violence is these romanticized notions of motherhood and protection. This is a cartoon from 1923 that it reads, and I printed it out here, that protection, motherhood is the noblest profession in the world. Therefore, you must be given inferior jobs, the lowest pay, and your hours for work shall be limited. I used to have a professor in college who said that her biggest fear was that one day the civilization would be uncovered far, far in the future, and they'd see piles of Mother's Day cards, and they would be under the false notion that we in this culture worshiped mothers, when in fact, we know that a women's lot across history and to this day tends to be much more marginalized in varying degrees, depending on other characteristics as well. So there was this combination of a sense of romanticizing the role of mothers and parenting without the kinds of protections and recognition of risks and harm, and of course, experiences of violence that we all are familiar with. Just a few years ago, I was in a session with a facilitator who had not worked extensively in the field, but was meeting with a group of domestic violence victim advocates. And he asked, "What do you all think is the cause of gender-based violence?" And the answer that the advocates in the room gave was misogyny. And he didn't know how to spell it. He was eventually corrected, but he spelled it the way it shows up here in this cartoon, which is a cartoon I drew, just highlighting what that experience of misogyny and oppression might look like, and imagining, calling up and getting a massage. That again, what kind of oppression is a reasonable amount? And of course, none of it is appropriate. All of it is a form of violence and power over. And it's one of the things that we have had to wrestle with over the history of intimate partner violence and the source or location of that violence, which of course is in many ways complicated, in some ways pretty straightforward. Uh, we also saw in the 1970s, Ms. Magazine has had a section called No Comment, where they would just post various examples from mainstream media, advertisements in particular, or signs around the country that reinforced notions of marginalization, oppression, misogyny, reflected the seriousness of sexism in the United States. And this was an ad for a bowling alley in that appeared in one of those segments. So some of this is helpful in terms of thinking about what has changed. It's very easy to look at all of this information and to feel some distance from it, but also, I think, to struggle with how much hasn't changed and how much more work there is to do. Again, I find it both inspiring and frustrating. Uh, but it reminds me that I'm part of a very long struggle, and that through that struggle, we can find connection, we can find joy, we can make a difference in the world, we can improve our experience and the experience of survivors and others in our community by working together on these issues. So we aren't the first folks to come into this work, obviously, and it is on the shoulders of many activists and advocates that I engage in this work. This may not seem as though it's a subject that's directly connected to intimate partner violence, but along the lines of thinking about the role of women in our community, and of course, I think often about the role of attorneys in this work. We had, when I was in law school, I graduated from law school in 1994. When I was in law school, you couldn't wear pants in the San Francisco court if you were a woman lawyer. And that was a regulation that was just well recognized and understood. And you can see here, I also included the story of a witness. Helen refused to wear a skirt as a witness in the court in Southern California and was held in contempt in jail and jailed for not being willing to wear a dress or a skirt to court. And it was in 1991 that the New York case came out stating that the Code of Professional Responsibility does not prohibit a female lawyer from wearing appropriately tailored pantsuits or other pant-based outfits. You can see these kind of very gendered notions. This was a woman who was interviewed just within the last, I think, 15 years about her experience of being an attorney in California, and that part of her job was to ensure that any women lawyers who showed up were reminded that they were not to be wearing pants in the courtroom. The judge would not handle that directly. So again, we see some changes in this area. And of course, a few steps back forward and too many steps backwards from, I think, many of our perspectives. Now, we're continuing to move forward in terms of thinking about the history in California and across the country, the women's rights movement, the civil rights movement, as we move through the 60s and 70s, efforts to put in place civil rights legislation from the federal civil rights legislation in the 1960s to voting rights acts. To an increasing awareness of the experience of domestic violence and the need to enact policies and develop resources to better protect primarily women and children from male violence, resulted in a network of grassroots homes that were purchased or opened to those who were experiencing domestic violence. A lot of that effort, again, grassroots within neighborhoods, mutual aid, without federal or state funding, often organized by women of color, by women who identified as lesbians, who worked in more marginal or underpaid positions. This was a lot of self-help that was going on. In 1976, La Casa was one of the first shelters that opened. Haven House also opened in the around this time. There was an increased sort of establishment of identified organizational structures. In the case of La Casa, an individual woman purchased a home and opened it up, and it was immediately full of women in need of housing. But you start to see the shelter movement developing in the mid 70s. You also start to see finally a civil remedy. So we're starting to move into policy development because of concerns about how often when women contacted the police, and this of course was happening way back for a social work paper I wrote when I was in social work school. It was about, I was looking into ride-alongs, social workers who were doing ride-alongs with law enforcement. And you can see at the turn of the last century that social workers often accompanied law enforcement to homes, to situations where there were concerns about violence. And eventually, over the decades, that was defunded and it became a new idea again within my lifetime. Uh, but the reliance on the criminal legal system to pursue protective remedies was limited, and there needed to be developed this, again, longstanding from the late 1800s notion that there was a way to find some kind of protection to stop the violence that might be driven by survivors themselves and not relying completely or at all on law enforcement and prosecutors. It was also around this time that we start to see criminalization of what is described as marital or spousal rape. That definition, what that really spoke to was this idea, again, dating back to coverture, that there was, once you were married, you lost your ability to consent to or to deny sex with your husband. And so it couldn't be a crime because that was part of the marital contract and it was part of coverture and part of what you acquiesced to by getting married. If you think about it, one of the most significant lingering effects of coverture is the fact that women are still in our culture expected to, in many situations, change their last name. That's left over from coverture, where the woman gave up the name that she had gotten from her father and took on the identity of her husband. Um, so we see that California makes spousal rape, just take out spousal there. It's a form of rape. It is rape, 1979. But that wasn't the end of that policy change, and we'll talk about that in a second. And then we see in 1984, California was one of the early adopters of this idea of dangerousness around the intersection of firearms and domestic violence. And that was soon after the 1980 implementation of orders of protection in the domestic violence context. We included restrictions on access to firearms. So we're developing an even better understanding of the types of behaviors that are dangerous. So we know over the last few decades, we've had a more developed understanding of the role of strangulation, the impact in terms of traumatic brain injury, certain types of violence. And we've also been recognizing for many years now, at least in some way, and not adequately enough, in my view, the significance of access to firearms in domestic violence cases. Now, when going back to my comments about marital rape statutes, the criminalization in 1979, we still in California included that concept that there was such thing as spousal rape or marital rape that was distinct from other kinds of sexual assault. A defendant's spouse who had been uh, found to be guilty or who had alleged to have perpetrated sexual assault within the context of a marital relationship could receive a prison sentence that was different from a non-marital situation. They could be, they didn't have to register as a sex offender. And that just changed in 2021 with AB 1171. So the struggle continues. The movement is critical, and the work we do builds on work that is done before, and it's not done. So we all have, I think, an important role to play in that. How we go about handling all of those policies and movement issues is shaped in large part by tensions in the movement that have existed for a long, long time, decades, probably since the beginning of trying to work some of these issues out, and differences of opinion and perspective and strategy in approaching dismantling violence against women, gender-based violence. We've had this tension, and this really became apparent in the 1970s and since between what was this grassroots approach and a more professional approach that started to emerge as funding became available. And I know that I have colleagues on here who have lived through that. It still pops up as an issue in our work today. But we know that some of the early analysis of violence against women and the suggested remedies were very focused on empowerment, community action, a critique of institutions. Sometimes the term radical feminist approach is used, radical meaning root. There was a real interest in going to the root of the problem. Whereas others were more focused on what became known as sort of the professionalization of the field. Yes, that might be true, that that's the source of some aspects of violence, but we also need to fund this work. We need to make these services available. And if that means we need to have someone who looks the part or who is more professionally educated at the head of a hierarchical organization that makes sense to funders, then that's what we're going to have to do. So that tension, I think, persists. And it's something I think we all need to be aware of and to negotiate around and with in doing this work. And it relates directly to this next point here, this tension in the movement. Of course, none of this is unique to California, but this idea of reliance on governmental funding. The Violence Against Women Act, a very important piece of legislation in terms of funding, came also out of a very problematic approach to policy, which resulted in mass incarceration starting in, well, before the mid 90s, but under the mid 90s, under that time frame where there was an increased focus on criminalization, imprisonment, and funding for approaches that resulted or contributed to ongoing issues related to mass incarceration. And so we see that tension there where the funding was critical, vital to addressing violence against women, but also contributing to violence in other and often related ways because it's not always that separate. We also see this somewhat of a tension or area that can be problematic and also incredibly, of course, critical. And I think a core tenet of the work that I've been lucky enough to be involved with, which is the beauty and joy associated with intersectionality and inclusivity, working in diverse environments with a commitment to bringing in the voices of those across the spectrum in terms of experiences of violence. But there's also that the challenges that go along with that. How to ensure marginalized survivors' experiences are included, how to be as inclusive as possible in terms of thinking about immigrant communities, those facing economic hardships, and institutionalized racism, concerns with poverty, negotiating the government around welfare systems. So the tensions around how to address bias, implicit and explicit bias, and those institutionalized marginalizational experiences, I think is really an important tension and opportunity for improvement in the movement. And then we see this tension between criminal legal system approaches and victim survivor autonomy. And that's something I think, I know I deal with on a regular basis is this idea of who's in the best position to ensure protection, to prevent violence, to improve outcomes. And it's very interesting because in this moment in the work I do around firearms violence prevention, we have a much better understanding of the fact that two-thirds of mass shootings have some connection to domestic violence. I use that statistic. I talk about it often. I think it should be concerning. I often, say if you don't want to focus solely on protecting a victim, be aware that removing the firearm can reduce risk for yourself, for those in the community. But the flip side of that is when we start getting to the point of, well, if she's not going to pursue protection, we're going to have to intervene because now my safety is at risk. And so she doesn't have the autonomy that we might otherwise want to support because the decisions she's making are so problematic for the rest of us. Or I know more because I've been trained on this and I'm in the legal system. And I believe that an order of protection is the best way to go. But if we don't incorporate safety planning into that, if we don't consider the voice and perspectives of survivors, we can inadvertently end up creating unsafe situations that that individual victim survivor will experience directly. So that tension also persists and has been around for a long time. Now, we couldn't get through this presentation without talking about one of the most significant domestic violence uh, cases in the history of California that has and continues to shape our policy work in this area. In 1994, Nicole Brown Simpson and Ron Goldman were murdered. And O.J. Simpson was charged, prosecuted, uh, found not guilty for the dual homicide. So he's acquitted in 1995. There's, of course, been a lot of documentaries and fictionalized versions of this. I started teaching a class in 1995 on race, gender, and law and violence against women, and then subsequently turned it into a class that was largely about this case because it was such a significant case and such a story about the intersection of class and race and gender and intimate partner violence and expectations around what the role of the legal system is, and such a stark reminder of the history of injustice for people of color in the legal system and how domestic violence was treated and understood for victim survivors in this country. We also had some subsequent cases. The guardianship decision came out in favor of O.J. Simpson, decided, of course, by one of our judges here in California. The court process itself was on display, so cameras in the courtroom. It was for many people this, sort of first glimpse and deeper understanding of what courtrooms look like, how judges adjudicate these cases, what lawyers do. So you cannot really overstate the case's impact in terms of thinking about all of these issues. And we, what we saw in the guardianship case with respect to the impact of violence on children, because it was undisputed that there was a history of domestic violence. But how domestic violence was understood and handled in that case was of a great controversy and discussion. And when the guardianship case was overturned in 1998, the appellate case said, which I think is very telling here, that they made this comment about how we were trying to improve our understanding of the impact of domestic violence on children, which is, again, an ongoing issue in our policy and practice. What happened as a result of that case, again, can't begin to describe its significance. The position that I ended up working under at the Judicial Council beginning in 1999 was one of two positions that was established in large part as a result of that case and of the attention court proceedings got and concerns about how courts were handling domestic violence in California statewide. It was also around this time, building on the work in the 1970s, the women's movement concerned about the practice of law for women attorneys and the experience of women who were going through the court system, both criminal and civil side of things. Court systems across the country started engaging in examination of gender bias in the courts. California had one of the early reports on this issue. And you can see here this definition from the report that came out in 1996. The initial report was 1990. It was a draft report, and then additional work was done on it. It was commission supported, funded by the Judicial Council. If anyone wants a copy of it, happy to make sure you can get it. You can Google it, but let me know if you want a copy of it. I'm happy to get that out to folks. But you can see their working definition here, the stereotypical attitudes about the nature and roles of women and men, cultural perceptions of their relative worth, and myths and misconceptions about the social and economic realities encountered by both sexes. And then gender bias manifested itself, as far as they were concerned, in many different ways. They talk about intentional bias. They talk about what we would refer to as explicit bias. And they covered a variety of issues, including, of course, intimate partner violence, as well as the experience of female offenders, those who were in the criminal legal system, those who are accessing the courts as jurors, the role of attorneys, and the role of court employees. So, how gender and gender bias was impacting folks in all aspects of court proceedings. We also have around this time the case of People versus Blackwell, which I think is again a milestone in understanding tensions and the history of our movement in California and policy development. So this was a case that came out in 1987, but began earlier than that. It received a lot of media attention. It was a situation in which Blackwell had been a victim of domestic violence for a long time, extensive domestic violence. And on this particular evening, her husband held a gun to her head. He did not fire the firearm. Um, she was initially prosecuted in 1984. So this was happening in 1984, 83, 84. So he holds a gun to her head, ends up putting it down on the table, walking away, and she shoots him and kills him that night in Napa. She is prosecuted for murder. She had informed medical professionals about the abuse she had experienced. She had applied for admission to a battered women's shelter, but had been turned away because there wasn't enough space. He had abused her right before he held the gun to her head and threatened to kill her. She fired the 5 shots. She's prosecuted. There was some testimony on battered women's syndrome, and she ended up being found guilty and was convicted of second-degree murder, sentenced to 17 years to life in prison. She appealed the case, and she based her appeal on the fairness of the jury. This is one of the things I find most interesting, and this is covered in the gender bias report as well. An individual juror later testified she had her own experience with domestic violence, but had lied during the process of becoming a juror and had denied any experience with domestic violence. And she said the reason why she voted to convict Blackwell was because she had gone through domestic violence experiences herself and was able to resolve those abusive relationships without resorting to violence. The appellate court ended up reversing her conviction, sent it back for a new trial, and on retrial, the judge, working with the lawyers, some jury consultants, they had a much more sensitive approach to voir dire, to identifying jurors. Of the 69 prospective jurors questioned in the second trial, 70 to 80% had previously experienced domestic violence, either directly or through a family member. So her conviction was overturned, and she was able to move on. This is a photo of her from one of the stories in the paper at the time. there she is in the Superior Court, sitting down in the photo on the right, waiting to hear the verdict. And there was additional testimony about battered women syndrome in the second trial as well. And we saw that same issue uh, in the O.J. Simpson case. So we know that the epidemic of domestic violence, this is a clip at the top there, a paragraph from the gender bias study from 1996 about how common what was referred to as battering or intimate partner violence, domestic violence as a phenomenon in our country is. And here noting that this is something we all need to work on in terms of finding solutions. But it was a similar issue in trying to seat the jury in the O.J. Simpson case, different perspectives and prevalence, of course, of domestic violence. So when this draft report came out, and I know the slide violates every rule of PowerPoint, but I wanted to provide you with some clips for you to just get a sense of what that report was like. We can see that it was a significant report, that draft report from 1990, sort of exposing the level of biases in the court system. And it was also in 1997, we also had the racial bias in the courts report. They came out and similarly described marginalization, bias, racism in court proceedings and in the experience of going to court with court employees. So this was a moment in the early to mid 90s of attempts to address, to highlight problems with bias in our court systems and our legal system. We see here that there's this emphasis on the issues I've highlighted. They covered intimate partner violence. They talked about child care, that the real experience of women navigating through our court system was infused with issues related to discrimination based on violence and based on gender, excuse me. The implementation report came out then later that year and went through some specific recommendations and related to what was happening nationally in this area. Again, I've highlighted 1993, the Conference of Chief Justices wanted further efforts around addressing gender bias in our courts. And I'm bringing all of this up because I think it's helpful to know what has come before. It doesn't mean the issue is wrapped up, taken care of, but we can learn some strategies. We can consider, is it time for us to look at following up on this? 1996, right? It's 2026. So 30 years later, is there more we can do to build on this work that was done by the third branch of government with leading legal scholars and activists around the state? So we can see since then specific changes that have happened as a result of some of this work. And that's where I think we can be inspired. We can identify some hope. And there are a lot of changes. And again, given our limited time, I'm only going to be able to highlight a few. So I know and apologize for the things that are being left out of this conversation. But this is a rich and deep area. You see in the report that one of the concerns at the time was that there was routine issuance of so-called mutual restraining orders, where a victim survivor would go in, petition the court for a restraining order, and the other side would say, well, she was violent against me. And again, it's a very gendered set of stories and examples. And without having to fill out any paperwork, the court would routinely just say, well, both of you should stay away from each other, and would issue restraining orders that were thought of as mutual restraining orders. We now have exactly what the task force talked about, which is the implementation task force talked about, which was to require that whenever somebody is asking for a legal order, that they go through the same process of specifically requesting and proving up filing the petition, proving up why it is that that order should be put in place. So we have what we can think of as restrictions on mutual restraining orders. Doesn't mean it doesn't ever happen, but we have policy in that area. We also saw in the gender bias report and in the implementation report that there were issues with allowing support persons to attend hearings or to go to mediation with victim survivors. And we specifically have legislative policy that allows support persons to attend both court hearings and mediation, child custody mediation, with those navigating those family law processes. Uh, we saw recommendations for emergency protective orders that were even shorter than the 5 to 7 days that we have today, uh, to allow a protected party under an EPO, what we think of now as an EPO 001, the restraining order that addresses intimate partner violence, uh, as well as child abduction, can also cover civil harassment and workplace violence. But the EPO 001 being lengthened so as to allow the protected party to reach out for safety planning help, and to work with an advocate to make a decision, again, looking at that autonomy piece, about whether or not a longer term order would be protective. Uh, we also know from the report that there was concern about diversion in domestic violence proceedings. And we have legislation in the penal code that restricts the use of diversion in domestic violence cases today. A lot of discussion around that currently, and questions about how it's been implemented. So I'm always curious about what you're all seeing in the field. But the idea was for those interested in bringing to bear the protections and accountability in the criminal legal system, how that was being taken away as a possibility when these cases were diverted. Again, stemming from some of these ideas that this is a private matter that does not necessitate interference from the criminal legal system, because these families are going to stay together and stay in contact. That tension and that struggle uh, persists and was one of the things that led to concerns about diversion. We have policy on that now. We also see throughout these reports a lot of emphasis on education and training. We now have mandates. We have in California a mandate for cosmetologists, those who are pursuing a license so they can be hairstylists, get their cosmetology license. They have a requirement that they have a domestic violence class. We have judicial education on domestic violence. We have mandates for child custody mediators and evaluators. I was just with a group of physicians over the weekend who are working on developing curricula for medical professionals. In some areas, that's been baked into policy as well. But we see for law enforcement and for court staff more broadly, more training on domestic violence, more mandates for training, and more ongoing continuing education training. So that's changed. If you looked at this from the 50s, 60s, and 70s to today, you see much more content being made available to players, stakeholders, those responsible for implementing policy. Domestic violence and child custody has been a huge area in terms of policy change. When I began in my position at the Judicial Council in 1999, Family Code Section 3044 was being debated and reflected what we know from the research, which is that domestic violence has a negative impact on children who witness or experience domestic violence. And the law was being developed to reflect that research. And yet it also restricts judicial discretion because it creates a rebuttable presumption that has to be overcome. This many years later, there's a lot of discussion about 3044 and its impact. We also have continued to amend it. So 3044 now has multiple references to concerns related to firearms. We just recently amended 3044 so that any violation of any restraining order, including the firearms prohibition. So if you violate a civil harassment order with respect to the firearm prohibition, that's going to be a concern that could preclude joint physical or legal or sole physical or legal custody and visitation to a party where domestic violence has been found to have been perpetrated in the last 5 years. We also have 3020, which states the legislative intent recognizing the seriousness of domestic violence. We have 3011, which talks about allegations, not limited to the last 5 years, but allegations of domestic violence. Those cases that include those allegations, the court has to give very careful consideration as to whether or not there's going to be unsupervised in-person contact, and there needs to be details with respect to the time, place, and manner of that contact. We have defined virtual visitation to provide an alternative because our supervised visitation facilities are so limited, and that in-person contact can only be ordered in cases where firearms might be a concern, when the court finds that in-person contact is in the best interest of the child. So again, much more consideration for that domestic violence, its impact on children, and access to firearms. We see that those changes, again, not enough to prevent every tragedy, and perhaps not even enough in terms of robust and fair implementation. But we see that interest and we see attempts to reduce the risk and increase safety in those situations. The recommendations also talked about improving access to justice by offering forms and services and programs in multiple languages. And we see that many of the court forms in the domestic violence uh, category of judicial council forms have been translated in the top 5 languages in California, so that some improvement has been made there. We know that interpreters need to be made available, translations need to be more available, and access to legal assistance that is culturally sensitive, informed, and available in multiple languages continues to be of great concern. Um, and there's a whole section on improving responses for female offenders who very often, as the report points out, don't receive information or opportunities to participate in proceedings involving their children in welfare institutions code or juvenile dependency proceedings, who may lose custody of their children, and for whom the experiences of domestic violence are often, too often, not adequately considered. But all of that is addressed in this report, and I think it's really worth digging into if you're thinking about legal strategy going forward. So again, around this time, we were looking at the significance of racial bias in this context as well. There was a story that's contained in this report, I mean, multiple stories, but one of them that I think is relevant for this conversation is a San Francisco attorney who told the story of a Black woman, a victim of domestic violence, who was eventually tragically killed by her husband, who was also Black. He was charged with murder. Bail was set at $30,000. At the same time, there was a case going on where a white female attorney was brutally raped by 4 Black men. In that case, the judge set the bail at $1.5 million. And one of the people testifying, when they took testimony from folks around the state about their experiences with the court system, um, it was uh, an attorney who had worked on that the case of the woman who was murdered, and was describing the bias that they saw as attorneys working on that case. Um, and just highlighting the value that's put on different people's lives as they navigate the court system, or we think about victim survivor experiences. Uh, that is highlighted in this report in multiple ways and led to policy changes as well that I think dovetail or intersect with the policies around intimate partner violence too. So this was very much a part of the conversation in the mid 90s, leading to policy changes, additional task forces, conversations about how can we improve the administration of justice. Around this time, we were also looking at sort of an expansion of where else can we be thinking about domestic violence. The Clarence Thomas, Anita Hill case highlighted issues around sexual harassment and workplace violence stemmed from that conversation that had been going on through the 60s and 70s as well. And so we start to see more policies around workplace and domestic violence issues, leave for domestic violence victim survivors, what kinds of resources. I worked for as a consultant in the mid 90s with a corporation to develop the first international employee policy on domestic violence, where they were using their internal corporate resources to provide support for employees who had experienced domestic violence. And that was, again, international, so around the world, which is a very interesting project culturally to see how different countries thought of the role of the workplace in terms of addressing domestic violence. We also see, again, moving in through the 90s into the 2000s, greater attention being paid. This is a report from 1999 from the National Council of Juvenile and Family Court Judges on the intersection of child welfare programs and domestic violence. So known as the Green Book, full of recommendations about how to improve issues related to what we think of as child dependency cases and the role of child protective services in addressing domestic violence, which also stemmed from too many examples of disproportionate marginalization for poor women, women of color, and their children, families of color having to navigate the child welfare system across the country. So that's a useful resource on which a lot of policy ended up being developed. We also see in 1980, California developed its mandatory child custody mediation framework. We were one of the only states to require that mediation be a process that every child custody case where there was a conflict over child custody, every case was required to go or is required to go through what we think of as family court services with no automatic exception for domestic violence. Another area of tension. The policymakers believed that, in large part, that by not having an exception, we were giving an opportunity to victims of domestic violence to negotiate an outcome that might not otherwise be ordered by the judge, and that you couldn't make an assumption that going before a judge was going to result in a better outcome, and that as part of that victim survivor autonomy, mediation should still be afforded as a service, a free service for survivors. At the same time, the reason why so many places said, nope, that's an exception, you don't have to go through mediation, is the power imbalance inherent in a domestic violence situation where the victim survivor is expected to negotiate for their own well-being against somebody who has engaged in violence against them and could be continuing to perpetrate that violence while the mediation is ongoing. We developed a whole set of policies around this because we don't have an exception. So support persons, screening for domestic violence, so that you could, as a mediator, decide if separate sessions were appropriate, address any requests for separate sessions if a protected party asked for them. So we have a whole set of policies that emerged in the late 90s, early 2000s because of that 1980 policy. And we're still wrestling with that today. Throughout the 70s and 80s, a lot of conversation about the role of batterer intervention programs. In the early days, many of them were tied to domestic violence shelters. Some of that grassroots work reflected individuals, activists in the movement around women's liberation, as well as the civil rights movement, and the role that many men were playing in terms of addressing violence against women. As that again became more professionalized and then became part of policy, we've been seeing a real shift in recognizing what that role might be for batterer intervention programs. There's been recent developments in that area here in California as we look at the efficacy of batterer intervention programs, as well as calls from survivors often for more effective approaches that can address accountability and a real deep interest in seeing behavioral change. So, again, we have had a history in California of some very creative programs that are based in jails and programs that seek to support families who remain connected because they have children in common or the relationship hasn't ended and prevents the violence from continuing. So batterer intervention programs, a whole other topic. And then we had a 2003 task force that the then Attorney General had put together that resulted in a report from 2005, Attorney General Lockyer's report on keeping the promise. And that 2003 task force included people across the state, from law enforcement, from courts, advocates, uh, a variety of folks who have worked in the field for a long time. Remember, the Family Justice Center movement is coming out of a lot of this work too. So folks associated with the Family Justice Centers and the Keeping the Promise, which is where the title of this presentation comes from, has really, and then the court's response to the Keeping the Promise report has had an enormous impact on where we are today. So I wanted to highlight that report for you as well. They addressed in the report the issue of obtaining and enforcing restraining orders, holding batterers accountable, law enforcement's response to health practitioner reports because of mandated reporting for domestic violence in healthcare settings. They took testimony from people from around the state. They talked about prosecuting misdemeanor domestic violence cases, and they highlighted a lot of very concerning examples of failures, both in the law enforcement field, where the Department of Justice, the Attorney General, had more purview and authority for change, and in court proceedings. And they highlighted some promising or best practices. It was described here as a roadmap for addressing these kinds of problems. And the Chief Justice in California was Chief Justice Ronald M. George, was very concerned about the description of the problems. Again, based on this now, what you understand to be this history from the gender bias and racial bias reports, and these ongoing concerns around how domestic violence was being handled. The kinds of issues that they talked about included reference to judges who were engaging in practices that made domestic violence restraining orders, family law orders, much less likely to result in the kind of protection they were designed and developed to offer. So not hearing TROs or denying TROs if there wasn't a police report. We still hear some of that, if there isn't physical violence, that we have now expanded the definition of domestic violence and your ability to get a restraining order to include not only disturbing the peace, but reproductive control and other behaviors that don't rely solely on physical violence. And yet we still see rejection of requests for protection when there isn't a history or allegations of concerns around physical violence. Uh, we have a host of remedies in this area, but judges were not allowing those remedies to be included in restraining orders, and modifying the orders to allow for contact, or in some instances, crossing out the firearm prohibitions. In fact, the Attorney General had a form letter that went to courts to let them know that domestic violence restraining order couldn't be entered into CLETS, into the California Law Enforcement Telecommunication System, because it had been modified, and with all of the writing around it and crossing out prohibitions, that order could not be entered and therefore couldn't be enforced. So that concern was raised. They also talked about, made some recommendations around the need for legal assistance in domestic violence restraining orders, and that there should be free legal assistance because of the need for access to justice, the burdens that are placed on victims. So we see recommendations again from 2005 on free legal assistance. This was also a time where self-help centers were being developed, and now in all 58 counties, we have free legal information and assistance with domestic violence forms. Not the same as having an advocate, but the court's response included the necessity of ensuring that self-help centers could assist with domestic violence restraining orders. And service of orders. I don't know if it's going to be helpful to know this was an issue then, and it continues to be an issue now. Although we have changed the law in California, AB 818 requires any law enforcement agency who's asked to serve a domestic violence order at the scene or anywhere to serve that order, and not just to be passing folks on to another law enforcement agency. So some efforts in recent times also to continue to address this important issue that sometimes too often interferes with an order actually being able to be effectuated. Um, so that was another part of the conversation. And I'm just highlighting some key points for this presentation. The recommendations and the data in there is extensive. Criminal protective orders. There were concerns that there were a lot of domestic violence criminal cases, but not a matching number of criminal protective orders. And of course, the court is mandated to consider a criminal protective order in domestic violence criminal cases. We now have several versions of criminal protective orders, all firearms and ammunition prohibiting for witnesses, for domestic violence cases, and in cases where a domestic violence victim survivor doesn't want a no contact order and doesn't want to have a protective order in place at all, the option of using the Judicial Council form for CR 162 to just prohibit firearms and ammunition without naming a protected party. So there was a recommendation here the Department of Justice look carefully at criminal protective orders, provide technical assistance, and look county by county about how criminal protective orders were being handled. Specifically with respect to the courts, and I'm highlighting that because I want to talk about the entity that responded to the Keeping Promise report in this last few minutes, which was the judicial branch. Judicial leadership, the need for domestic violence courts, having co-location of criminal justice agency and victim service agencies. And I'm talking to family justice centers here today, so you know about that. That is a movement built on these ideas of coordinated community responses and co-locating services. But it wasn't always there, and so we benefit enormously from the work, recommendations, and advocacy of people who came before us. The importance of data collection, resources. We know how important those resources are for those delivering these services and for victim survivors and their families. And Court Watch, a recommendation that persists across all sorts of policy discussions and discussions around advocacy strategies, having people in these courtrooms, they are open courtrooms, people who can observe what's going on, who are in a position to report back on promising practices and problematic practices. Uh, Really important key recommendation in keeping the promise. And the judicial branch responded, and that was with the establishment of the Domestic Violence Practice and Procedure Task Force, led by the same staff, Bobby Welling, who had led on the gender bias study and had been involved with implementation of recommendations from that report. Uh, that report said we shouldn't have non-CLETS domestic violence restraining orders built on keeping the promise and developed additional recommendations. That there were too many instances where domestic violence was alleged and similar to, bargaining one's way out of accountability, that by not entering the order into the CLETS database, enforcement became difficult and prohibitions on firearms and ammunition were not included. So the efficacy of using domestic violence restraining orders that way was a problem. We now have a policy that says courts are not to be issuing so-called non-CLETS orders. We also had a recommendation in this report about looking at the database automated firearm system to find out before an order is issued whether or not someone is registered as having firearms, what those firearms are, so that we can better ascertain whether or not they have complied. And we now have SB 320 and extensive relinquishment requirements in the domestic violence context that require the court report non-compliance, the civil court report non-compliance to the prosecutor and law enforcement when someone has failed to relinquish their firearms. Huge shift from a policy perspective to have the civil court informing those responsible for following through around dangerousness to be making those reports of noncompliance. We also have a change in policy that has had a significant impact on compliance, which is that the courts in these matters need to tell the person who becomes prohibited how they can comply. And we've seen an uptick in compliance without a significant law enforcement intervention or court intervention, just because they've been providing information on how you can relinquish your firearm by storing it or selling it with a dealer or law enforcement, and then providing proof in the file. And we developed funding, one-time funding, pilot projects to support implementation in this area. So we've made some changes. We see additional themes developing. These are blog posts from 2020 from the California Partnership to End Domestic Violence, which of course has played a critical role. And these are many things that I've highlighted already. You see with California Partnership to End Domestic Violence's work, and you see with the Family Justice Center's work, we are increasingly understanding that we need to take a comprehensive approach to improve economic stability, housing, and other access to resources for victim survivors. It's not just about the legal response, it's about changing circumstances to provide more protective future. And we see more policy work around addressing bias than a few decades ago as we came into greater understanding and organized around those particular issues. We also see more of an emphasis on healing and accountability. At the same time, we're dealing with very significant concerns around funding. So these are some headlines from recent blog posts at CPEDV where you can see we are fighting, we're engaged in litigation in the movement to protect government funding, to prevent government policies that have the potential and have, in fact, created enormous harm. Immigration, of course, is at the forefront of policy work and litigation in this area, too, denying access to court remedies, hugely problematic in the immigration context where people may not, should not feel safe accessing certain legal remedies as a result of the immigration crackdown. So we're living through that, but we have a framework for how to organize, how to develop approaches that can increase safety and challenge efforts to do away with the work, the progress we have made. We see, that the whole idea of what we should be working on has expanded. We're talking about the whole, domestic violence across the life span. This is, from Futures Without Violence and their approach, the future of the Courage Museum, drawing attention to the various ways that violence shows up in our communities. So this is just their website from this week where we see greater attention to understanding the intersections of other forms of violence, uh, sexual assault, child abuse, elder abuse, human trafficking, a much more comprehensive approach than when we think about the last century or even 30 years ago. We see organizations that are talking about generalized safety. So, community safety, domestic violence as interfering with our safety generally in our community and our families. We see that we had an 8-1 decision by the U.S. Supreme Court in 2024 upholding the federal firearm prohibition in domestic violence cases. 8-1 decision. Clarence Thomas, Justice Thomas being the one dissenter in that case. Every other member agreed with the majority opinion by Chief Justice Roberts, recognizing the dangerousness of domestic violence. And Sonia Sotomayor's opinion is an excellent one to read on the dangerousness of domestic violence in particular, her concurring opinion. And we see an emphasis on restorative practices, on the value and importance of diversity, including diverse voices of survivors, addressing again the various ways domestic violence shows up in different communities, uh, recognition of domestic violence in the LGBTQ plus community, the need to be really, this is from Black Women Revolt, the annual report, one of my favorite photos for addressing domestic violence, talking about liberation and joy and support that can emerge from all of this work.